The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 907, coming to you on Monday the 30th of July 2018. On this program, I will speak to you on the topic, the Caribbean Court of Justice, Part 2. But before getting into the topic, a few preliminary comments. Firstly, condolences go out from me to all those families which have suffered recent bereavements, particularly those families who have lost loved ones by reason of violent death. To dear friends of mine, clients of long standing, I talk about over 25 years, in the Georgetown area passed away recently. Mr. Joseph Atman, my condolences go out to his family. And Mrs. Mylene Russell, my condolences go out to her family on their recent passing. And tomorrow we have the funeral of my good friend, same age, Brother Garnet Oliver from Rockies, who will be laid to rest tomorrow afternoon. I was misinformed last week when I said it was going to be last week, Tuesday. And let me send belated birthday greetings to my daughter, Mandela, who celebrated last Friday. And some persons were intrigued when I made the comment during Mandela Week, at the beginning of Nelson Mandela Celebratory Week, when I commented that my wife and I had decided to call the child in her womb Mandela. You're talking about July 1987, almost 3 years before Mandela was actually set out of prison. She was named when he was yet a prisoner. He was freed, of course, in 1990. And went on to achieve the presidency of South Africa. Belated happy birthday, Mandela. All right, let's get into the topic, which was started last week, the CCJ, the Caribbean Court of Justice. I have some materials to read for you in the course of this program. But I wish to correct one error of which I became aware when I saw in a printed medium in St. Vincent someone saying that St. Vincent doesn't belong to the CCJ. So what is the fuss about Justice Adrian Saunders being at its head? Now, the notion that St. Vincent and the Grenadines does not belong to the CCJ is wrong. All signatories to the revised Treaty of Chaguaramas are members of the CCJ because the CCJ is the designated CARICOM court to handle disputes arising out of the Treaty of Chaguaramas and the economic and trading arrangements between CARICOM countries. And I took the time to bring some information out to you. Now, the revised Treaty of Chaguaramas was signed on the 14th of February 2001 by Antigua and Barbuda, Barbados, Belize, Grenada, Guyana, Jamaica, St. Kitts Nevis, St. Lucia, Suriname, and Trinidad and Tobago, 10 countries. And then on the 15th of February 2003, St. Vincent and the Grenadines and Dominica signed on. Therefore, St. Vincent and the Grenadines has been a member of the CCJ since February 2003. And it is not correct to say that we have nothing to do with the CCJ. Now, as I said last time, and as you should know by now, the CCJ is really two courts in one, or one court exercising two jurisdictions. In the first place, it is the CARICOM International Court. All members of CARICOM, when they signed the revised Treaty of Chaguaramas, accepted the authority of the CCJ to handle disputes arising out of the revised Treaty of Chaguaramas. One of the strengths of the CCJ is its financial independence. And the framers of the originating documents for CCJ went to great lengths to make sure that the court would not be dependent on any one government for its financing. Therefore, they set up a CCJ trust fund of 100 million United States dollars. That fund was contributed to by all the countries which signed on to the CARICOM arrangements. And I'll tell you in a while how much St. Vincent paid. In addition to the countries guaranteed a loan from the Caribbean Development Bank to make up the 100,000 investment portfolio that constitutes the CCJ Trust Fund. Therefore, unlike all other courts in the area, all other appeal courts, the CCJ does not depend on what the government puts in a budget and doesn't have to wait on government ministries of finance to send money when the end of the month comes to pay staff and all the expense of running the court. The trust fund of $100 million ensures that the CCJ is not beholden to any one government. Therefore, no government can pressure the court financially, threaten to withhold its money. You know, sometimes in other circumstances, a leader of a country gets annoyed with a higher court and decides to play the fool with the funding of the court. That cannot happen with the CCJ. It is independently financed, and that $100 million has been invested, and the proceeds of the investment, the profits, if you like, of the investment, the returns on the investment, provide the recurrent expenses of the CCJ. All the judges are paid. The judges haven't got to wonder from month to month if they would be paid, or whether the bills for the courthouse would be paid and whether other expenses would be paid. That is guaranteed. The contribution St. Vincent made towards the 100 million trust fund was $2.11 million. That works out, according to my calculations, to 5,672,102 Eastern Caribbean dollars. That is what St. Vincent has already invested in the CCJ since 2003. In addition to what is called its original jurisdiction, that is dealing with the CARICOM matters as a Caribbean International Court, The CCJ also functions in an appellate jurisdiction. That is, it functions as a final court of appeal from the courts of appeal of those countries which accept its jurisdiction. So that is what I mean when I said at the beginning, it is two courts in one, or it exercises two kinds of jurisdiction. An original jurisdiction, where you can only go to the CCJ if you have a dispute involving the interpretation of the revised Treaty of Chaguaramas. You cannot go to the High Court in any of the participating countries to deal with those CARICOM matters which fall under the treaty. You have to go to the CCJ. Therefore, it has been our court in its original jurisdiction since 2003. However, in its appellate jurisdiction, it has replaced the Privy Council in 4 of the participating countries: in Guyana, Barbados, Belize, and Dominica. In all of the other CARICOM states, the Privy Council, except Suriname, of course, the Privy Council is still the final court of appeal. And the debate, therefore, over the years, not just last week or week before the last, the debate over the years in many countries has been the question as to whether they should move from the Privy Council to accept the final judgments of the CCJ. As far as I know, St. Lucia, Antigua, and St. Kitts, and according to some reports, Jamaica, are already making plans to reactivate their constitutional mechanisms to get from the Privy Council to the CCJ. Grenada is planning to do that as well. And the Prime Minister of St. Vincent and the Grenadines, when we had the special sitting of the CCJ, the ceremonial sitting on the 20th of July, the Prime Minister announced to the nation that he is ready and willing to take a bill to Parliament as the first step towards removing the jurisdiction of St. Vincent, of the Privy Council, from St. Vincent. In other words, from switching from the Privy Council to the CCJ. That is going to be, or has already been, the subject of a national debate. Naturally, not everybody would agree with that move. There are prominent voices which have said that St. Vincent should remain under the Privy Council. As far as I can tell, no adequate reasons have been put forward as yet, but these are early days, and as the debate develops, I look forward to hearing the arguments made by those who insist that you should remain with the Privy Council. As you know, I have been firmly for the removal of St. Vincent and Grenadines, in fact, from the Judicial Committee of the Privy Council to the CCJ. I have very strong views on the subject. Other people have strong views in the opposite direction. And in the course of time, I will be putting forward my views along with reasons. And I suspect they would be regarded as solid reasons why we should get away from the Privy Council and go to the CCJ. Not that there's anything inherently defective about the CCJ. I'm not saying, and as I said when I spoke at the ceremonial session on the 20th, I am not decrying or running down the Privy Council's quality of decision making. They are excellent judges. Of course, they are the judges who have been buttressing the legal system in England from time immemorial, and the successors to those who have gone on before. So the question is not inherently the quality of the Privy Council decisions, even though in some areas their lack of acquaintance with Caribbean conditions has proved a handicap, as they themselves have acknowledged from time to time. Because a final court is supposed to embody the aspirations of a people for whom it is the final court. And our starting point, that is those on the side of moving to the CCJ, our starting point is that if a country calls itself independent, it cannot be completely independent if it depends on another country for its final laws, the interpretation, finally, of its legal disputes. So the logic of those who insist we should remain with the Privy Council, that logic should say we should not have become independent, we should have remained under the British umbrella and let the British run our affairs. Because that argument says we are not really capable of managing our judicial affairs. So that while we are capable of managing our economic affairs and our political affairs, because we have our own government, that argument says, we manage our own political affairs and our economic affairs, but we're not really able to manage our judicial affairs, our legal affairs. We need the British judges to read and spell for us. So that the argument that we should remain with the Privy Council fundamentally is an argument which portrays an inferiority complex. It says that somehow Caribbean justice is inferior to British justice. That is what it says. I mean, you can't get away from that. Because you can't say our judges are not learned in the law. You can't say our judges are not competent. You can't say they are susceptible to bribery and to pressures from politicians, because there is no evidence of that. Look, you remember last week I told you I would continue last week's program, the same topic, this week, Monday? Well, as I usually do, one of the first things I do when I get up and about on mornings, whether I'm at home or in the office, I check the Privy Council website, because they publish every judgment from wherever parts of the world the judgment comes. On the morning it is delivered in London. And I go on the Privy Council website every working day. And once I see a judgment from the Caribbean, I print it out. My office is full of Privy Council judgments from the whole Caribbean. And if it is from St. Vincent, I make several copies, but precious few appeals have gone from St. Vincent in the civil law. So this morning, the 30th of July 2018, when I went on the Privy Council website, what did I find? I found 4 judgments which they delivered in London this morning. One from the Pitcairn Islands, this is in Oceania, but 3 judgments from the Caribbean. And interestingly, all 3 judgments from appeals filed against our Court of Appeal. One from Anguilla, and 2 from the Virgin Islands. I have them here. And those of you who go on the Privy Council website and haven't done that for the day, as soon as you get a chance, go on the website, you will see them. The Caribbean judgments are UKPC 20. Sorry, that is the one from Pitcairn Islands. UKPC 21. Two are number 21. Ghani Holdings and Khan and others. And Rangoonwala versus Khan and others. Both Virgin Islands, British Virgin Islands appeal. And number 22 of 2018, UKPC 22 of 2018, Harding versus the Attorney General of Anguilla. Now, in all 3 of these appeals that went from the Eastern Caribbean Court of Appeal, the Privy Council ruled that the Eastern Caribbean Court of Appeal was correct, and all 3 appeals were disallowed this morning. So for those who feel that our Court of Appeal is not of the caliber to deliver proper justice, and our judges in the Caribbean are not of the caliber, Justice Saunders, when he spoke here on the 20th, went through the figures and told us that of the 21 appeals that went from St. Vincent and the Grenadines to the Privy Council in the last 30 years, he told us 9 were death penalty cases where the British lawyers do them pro bono, free of charge. They get paid from a fund. Not their full fees, but they do it out of a willing spirit. Thank them. But the other 12 appeals from St. Vincent and the Grenadines, in 8 of them, the Privy Council ruled that our Court of Appeal was correct and turned down the appeals, and only in 4 cases did the Privy Council overrule our Court of Appeal. And therefore, the evidence shows that the quality of our judiciary, not just in the Eastern Caribbean, but throughout the Caribbean, is of an extremely high standard. And therefore, those who criticize moving from the Privy Council and who say we should remain with the Privy Council can't say that Caribbean justice is not of the quality to satisfy the demands of modern states trying to forge the way ahead. The CCJ has adopted from morning this one of several rules to protect it from political influence. In the appointment of judges, politicians have no say, except when it comes to appointing the president of the court. The politicians, that is the heads of government, respond to recommendations by the Regional Judicial and Legal Services Commission, which makes the recommendation. The heads of government can't recommend who should become the president of the court. They can only respond to a recommendation from the Regional Judicial and Legal Services Commission. And another rule adopted by the CCJ to ensure the independence of its president, the president has a one-term term of office, 7 years. He cannot be reappointed after 7 years. He sits for 7 years, amen. So no head of government can pressure a president of the CCJ and say, look, I am annoyed with the judgment you decided, and when you come for re-election, there'll be trouble. No. No politician can pressure the president of the CCJ. He is there for 7 years, and he could only be removed from his behavior in office by a long, cumbersome process. So the independence of the court is guaranteed. Its legal integrity is known. It is our court. But note, the CCJ has always appointed judges who are not necessarily Caribbean people, because the CCJ just doesn't feel, and the system doesn't want to say we should have nobody there from outside. Yes, the court does have people who are not from the Caribbean, but very few. The judges on the CCJ are thorough, they are sound, they have a good temperament, and they belong to us for the most part. One final word. I mentioned the trust fund of $100 million US. Since 2009, one of our own legal barristers has been on the trust fund committee, and he's not a member of the government party. He's Dr. Linton Lewis. Since 2009, he has served on the trust fund committee as a representative. And since 2013, Dr. Linton Lewis, a Vincentian barrister, has been chairman of the trust fund of $100 million US, which runs the CCJ. Now, arguably, apart from the court itself, the leadership of the trust fund must be the second most important personage in the CCJ. Therefore, we have at the top of the CCJ the president, being Justice Adrian Saunders, a Vincentian, and the chairman of the $100 million US trust fund, a Vincentian. And therefore, two prominent Vincentians, Dr. Lewis and Justice Saunders, are at the reins of the CCJ. And you want to tell me that is not powerful reason for St. Vincent to consider joining the appellate jurisdiction of a court in which it has already invested $5.672 million EC dollars? I will continue with part 3 of this series next week, Monday, Divi, because I want to read you from a publication, and the section I want to read you is headed Support from the British Legal Establishment for the CCJ over the Privy Council. And this extract will quote the names of British prominent judges and give you what they have said in support of the CCJ, while our own people are denigrating the CCJ and saying we need a referendum and so on and so on. As to the lack of need for a referendum, I will go into that next week, Divi, and show you that the Court of Appeal's decision on the Attorney General of St. Lucia's reference is that St. Vincent and Grenadines and St. Lucia, indeed, well, the judgment was about St. Lucia, but our constitution is similar in that respect. St. Lucia doesn't need a referendum to change from the Privy Council to the CCJ. Just as there are other sections of our Constitution we don't need a referendum to amend. And in our recent history in 1986 and 1988, we amended our Constitution once in those years, once in 86 and once in 88, without the need for a referendum. And the Court of Appeal has ruled you do not need a referendum in St. Vincent. What you need is a 2/3 majority in Parliament. But my time has been exhausted. I know I got a little animated, but this is a subject near and dear to my heart, so you forgive me, I'm sure. All right, well, that is all from this edition of The Law and You, program number 907. I look forward to being of further service to you next week, Monday day, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.